if you're likely to get it, I mean, just sit back and think what you're gaining.
Yes.
And then if you are still pushing ahead and you want that declaration, we will have to examine it. And even this closure or whatever, if this happens, I mean, one is just, this is completely, please let me complete. There is nothing, there is no closure. What I'm saying is, if there is some quietus to this at this stage, don't see this as the end of the battle, or whatever your movement is. Because ultimately, whatever your movement for equal recognition of equality of, that would always remain. And even if these, whatever you get, the positive part of it, even if you don't accept this or partly accept this, now that too will not be the end for whatever you are going to do. One is speaking generally, not in any manner prejudging it.
My lords, in Obergefell and in America, the experience was that after Obergefell, when the Supreme Court gave its broad declaration, broad and firm declaration, the council for the parties then sat with the government, with the administration, and went through each law. And each department sat with them and they went through each law. I'm told it's 710 laws or something, and then sat down line by line and sorted out post the declaration in Obergefell.
But that was a different kind of, let's say, working out, because they had to work out what was unconstitutional. Oh, we are literally putting the alphabet together.
Yes.
That much harder.
But my lord,
And even
And not
there are
only-
good
not only
reasons in
mere
the
laws,
minority
there were
views also.
constitutions. There were constitutions which had to be invalidated.
But my lords, the only thing I will say
In
is that
fact,
we as
in my lord,
jurisdiction,
this
we-
judgment my learned friend is relying upon,
we as a
there were
jurisdiction,
restrictive
constitutionally-
statutes which came before the Supreme Court.
but we as
Some
a
states had
jurisdiction-
restrictive.
Mr. Solicitor, coming
My
back
lord-
to your submission, let's get on with
Yes,
that in
that's
another
very
10 minutes. We'll put
We'll
we'll put the
reflect on-
next
yes, yes,
batsman
please.
in,
We'll
and
deal with
I believe the
Yeah,
next
my lord,
batsman will be
only,
learned
lord,
batsman
only
as well.
one request, my lord, to the other side. While giving the suggestions, Lord, I would request them not to give jurisprudential ideas, etc.
No, not at all.
Only-
That's for us.
Of course not.
Only
Again, in third
factual
category,
problems
Obviously.
which can be addressed by the
jurisprudential is for this
administrative
side, but
ministry.
not that side.
There's no delegation of the judicial power of the court.
Yeah, yes. That's all.
Jurisprudential
No,
only
it
this
there
side.
can never be, there can never be. A lot of
Singhvi?
shoulders are the strongest. But it may not happen, my lord, that the committee doesn't understand what the issue is. Let it be as simple as possible. That's all.
Little legal training.
Dr.
Make
Mr.
it-
Solicitor,
make it very
we've
specific.
now heard your submissions. We are now almost at the wrap-up point of your submissions. The jurisprudence which we have considered, and your line of submissions, I think there is an area which, even according to your submissions, then that the court can go into, namely to recognize that same-sex couples would have a right to cohabit together, and cohabit together in a normal, peaceable environment in our country without any form of discrimination, either societal or otherwise. Step two, that the government would, as we now see from your very fair suggestion that the cabinet secretary, no less than the cabinet secretary, would be going to it, would be recognizing the incidence of that cohabitational relationship. So we can certainly build upon our jurisprudence as going to that level. Question now is, and we don't want to stop them, whether we make that extra mile, which is what they have argued. And we have also argued that, look, this part would be a legislative exercise, don't step into that. So now what else remains? You can
Lord,
now wrap
can I
up in 5
conclude
minutes
in
so that we can
15
have
minutes?
someone else.
I'll wrap up in 15 minutes, my lord. My lord, I have filed one note. I'm not going to read it, my lord. At the outset, I may put that caveat, my lord. But there are only 3 points, my lord, which I am making. My lord, note 3, my lord, it's circulated yesterday.
Is she note 3?
Note 3, my lord.
You sitting and I was arguing.
Well, I'll just give broad propositions and I'll not read it, my lord, what is not relevant. My lord, my first point, that recognition of marriage is not a fundamental.
There's a note one.
I'm so sorry, my
नहीं,
lord.
उसके नीचे है.
Note 3, my lord.
Notes by Mr. Mehta.
उसके बाद नीचे है थोड़ा सा.
Yes, so that's this.
No,
Note
उसके बाद.
three.
So
Last time.
Yeah, this was cited last.
the title is closing points.
Closing points.
My lords are
No, closing arguments. Closing arguments.
closing points. my lord.
नीचे और नीचे. उसके नीचे.
Yeah. Closing arguments.
Yes, and my lords, my lord, I am obeying the continuing mandamus, my lord. I am
This one.
using the iPad, my lord.
Ah, that's good.
So a weak student, my lord, in at least schools I studied, used to get 5 extra marks for good handwriting. My lord, I need 5 extra marks, my lord, for using this one on the lighter side. My lord, my first proposition is right to get a particular social relationship recognized as a marriage is not a fundamental right, my lords.
Let's
Which,
read it quickly. Let's read the note.
yes, but I'll just quickly, my lord, go through. It is submitted that over and above marriage, there are a whole host of human relationships which exist in society, which may in some cases be even more valuable than marriage. The statutory law in any country in the world does not regulate all human relationships. The said relationship may be extremely important from the perspective of life and liberty and the dignity attached to it, and may further even have a more profound impact on the life of a person. However, sans a legitimate state interest, legislatures across the world have left a whole host of human relationships completely outside the legislative purview, denying any legal recognition to the same. It is submitted that the presumption, therefore, cannot be that the state is obliged to recognize all human relationships. Rather, the presumption has to be that the state has no business to recognize any personal relationships unless the state has a legitimate state interest in regulating the same. Even for heterosexual couples, it's their intimate relationship state had no business to regulate or recognize. Why the recognition came? Marriages used to take place even prior to 1956 because the court felt that we will have to regulate. You cannot be at free will marry at any stage, any time, at any age. You cannot marry as many times as you want. You cannot just say bye bye and leave the relationship. You can part with your spouse only on certain grounds. When you are in a relationship, the children might be there. Who will take care of the children? So the question of custody needs regulation. Who will pay the alimony to whom? So alimony provisions came. So state should step in only when the state feels that it is in legitimate state interest to regulate a relationship, and therefore recognition is only a consequence of that decision. Lord, hypothetically, Lord, para 3, it would be possible for a new religion, Lord, suppose new religion comes, to provide for a new form of marriage and new ceremonies for the same within the heterosexual fold. Lord, marriage, Special Marriage Act or Hindu Marriage Act doesn't provide for any particular mode of marriage. Except, Lord, in case of Hindu Marriage Act, it is that Saptapadi, etc. But suppose, Lord, someone just garlands each other in a temple. It's a valid marriage. Lord, would a new law providing for a new mechanism be under an obligation? New religion providing for a new mechanism of marriage be under an obligation that would be having a right that the legislature must accept that kind of a marriage as well? The answer would be no. Lord, thereafter, my lord, the fundamental right was essentially based upon two judgments of your lordships. One was Shafin Jahan and another was, my lord, Shakti Vahini. My lord, in none of the judgments your lordships were even remotely considering right of non-heterosexual couples to marry. My lord, in Shafin Jahan, please remember, my lord, the facts. One lady, Hadia, a Hindu girl, converted into Islam, was seeking to marry a Muslim boy, and the family of the girl were objecting. Non-state actors were objecting. There, your lordships, my lord, in a habeas corpus jurisdiction said that it's their right to marry because they are heterosexual couple, and your lordship specifically said that Muslim personal law allows the marriage. You have no business. The presumption was that it was a valid marriage recognized by the law, namely the personal law, Muslim personal law. Your lordships, my lord, never remotely considered marriage as an abstract proposition to be declared a fundamental right, or marriage amongst non-heterosexual couples as a fundamental right. Your Lordship.
Mr. Solicitor, conceptually, there's a little bit of difficulty about this argument. I mean, we understand the drift of the submission. Their argument is not that the state is duty bound to recognize all relationships.
Yes.
You are saying that, look, there's a gamut of relationships in society. The state is not bound to recognize all relationships in society. Their contention is that by not recognizing same-sex relationships for the purpose of marriage, the state is acting in a discriminatory way. So the argument is really of the anti-discrimination principle, not so much that the state is bound to recognize it or recognize all relationships in society. They say that marriage is a very vital social institution, step one, that same-sex couples are entitled to the same right to dignity as heterosexual couples, and not recognizing that relationship within the fold of regulation would be to deprive them of all the societal benefits which attach to marriage, and therefore it's discriminatory. So that's the line of...
To which, my lord, I don't wish to repeat, but my lord, just to paraphrase once again, my lord, our respectful submission, my lord, is that this is a reasonable classification.
That's fair, and that you have made your point.
I have already made
now,
it.
Shakti Vahini and this you have dealt with in point 5, right?
Yes.
You want to read that, or you've dealt
Lord,
with
only highlighted part, my lord. Your lordships may come to page 3, my lord.
Page 3, all right.
This is quotation from, my lord, Shafin Jahan.
Okay.
Where your lordships are very careful, my lord. The only highlighted part, underlined part. But the High Court unwarrantedly took exception to the same, forgetting that parental love or concern, my lord, daughter's parents, my lord, whose girl converted into Islam, concern cannot be allowed to fluster the right of choice of an adult in choosing a man to whom she gets married. That was, my lord, the broad conspectus that law permits a marriage between heterosexual couple. One is man, one is woman. The family has no business to interfere. Then, my lord, in Shakti Vahini was a different case.
That was a Khap Panchayat case.
Khap Panchayat, my lord, completely non-state actors, either by making regulations which they were not permitted to make, or by honor killing and other, my lord, extrajudicial unlawful means they were preventing. And, my lord, at page 4, if you're
point number 8 of your submission, where you have summarized what you're now saying.
Yes, my lord.
Therefore, it is submitted.
Yes, my lord. Therefore, it is submitted that said judgments were given in the context wherein state or non-state actors hindered the choice of a woman to marry the man she wished to. It is submitted that therefore there was an invasive positive act by the state or non-state actors in disallowing the exercise of choice in a heterosexual relationship despite marriage between them being recognized by law. It is submitted that said judgments are not, my lord. Then, my lord, kindly see, I'll not read it, my lord, but this Brown versus Board was cited by Mr. Vishwanathan. My lord, just to argue the separate but equal theory. My lord, this was a case similar to, my lord, what the situation was in India prior to independence with regard to some section of the society. They cannot sit in the same compartment. They cannot sit in the same place. There were different, my lord, provisions made, different classifications made for blacks versus white. So it was a racial discrimination. There was no intelligible differentiation. And in that context, my lord, the Honorable Court said that it is not, my lord, your lordship's approach, my lord, para 11, I have, my lord, respectfully urged, my lord. Further, it is submitted that there cannot be a fundamental right, either under Article 14 or 15, to seek recognition to all forms of social relationships. It may be noted that the legislature does not seek to give recognition or any special status to all forms of human relationships. It is submitted that this Honorable Court ought to approach the present question not merely in the linear reductionist sense, as sought to be, my lord, made. This is, my lord, this is a classification made on the basis of nature of relationship. There is a reasonable nexus with the object. Object is the family, family as a unit, family having all incidents of the family, and continuation of the human race. So, my lord, I'm not, my lord, repeating. I have already made my submissions, my lord. My lord, Citizenship Act and Foreigners Act, my lord, was thereafter not pressed. But, my lord, for completeness, my lord, at page 6, I have, my lord, put my submissions. I don't wish to repeat because they also very fairly did not press much upon it, my lords.
But then,